Good evening, everyone, and welcome to the final round of the Ames Moot Court competition. My name is Rachel Chu, and I am the Vice President of the Ames Moot Court program. On behalf of the Board of Student Advisors, I would like to welcome you all to the Ames Courtroom and say that it has been an honor and a pleasure for the board to oversee and administer this competition. We are particularly thrilled to introduce you to the two final teams. Two teams who have risen to the top of an unprecedented year of Ames in which a record 54 teams participated. Congratulations to both teams for reaching tonight's final. Presiding over this year's competition are the Honorable Justice Sonia Sotomayor of the United States Supreme Court, the Honorable Justice Goodwin Liu of the California Supreme Court, and the Honorable Rachel Kovner of the United States District Court for the Eastern District of New York. Our sincere thanks to our esteemed panel. We would also like to thank our case writers, Joseph Pasamato and William Bergstrom, both Harvard Law School class of 2017. Tonight's case turns on the scope of rulemaking authority granted to the Occupational Safety and Health Administration by its Enabling Act. There are two questions presented. The first, whether 5 U.S.C. Section 7062 of the Administrative Procedure Act requires courts to vacate agency rulemakings found to violate the act. The second, whether if so, 5 U.S.C. Section 7062 violates Article 3 of the United States Constitution by requiring federal courts to exceed their judicial power. A more detailed case description can be found in your program. I'll now announce the teams. Please hold your applause till the end of all of their names. Representing the petitioner, the United States Occupational Safety and Health Administration will be the Patsy Takemoto Mink Memorial Team, consisting of Derek Choi, Kunal Dixit, Daniel Flesch, oralist, Phoebe Kotlikoff, Yusuke Tsuzuki, and Monica Wang, oralist and also team captain. Thank you. Representing the respondent, Federici Contracting LLC, will be the Judge Laurence H. Silberman Memorial Team, including Max Alvarez, Eric Bush, Richard Dunn, oralist, Hayley Isenberg, oralist, Jessica Flores, captain, and Brandon Sharp. Before we begin, a gentle reminder that no laptops, cell phones, or other electronic devices may be used during the competition. Please take this opportunity to confirm that you have silenced any electronic devices you might have on you. Please do not take photos during the competition, and please refrain from leaving the courtroom during arguments. Finally, following the announcement of awards, there will be a reception at the HLS Pub located in Wasserstein Hall. We hope to see you there. Thank you very much, and we hope you enjoy tonight's competition.
All rise. The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Counsel, are you ready?
Yes, Your Honor.
Please proceed.
Madam Chief Justice, and may it please the court. My name is Daniel Flesch, and along with my co-counsel, Monica Wang, I represent petitioners OSHA and the Department of Labor. I will be speaking for 16 minutes on the jurisdictional and statutory issues. Ms. Wang will then speak for 16 minutes on the constitutional issues. We'd like to reserve 3 minutes for rebuttal. The APA does not mandate vacatur in every case. Instead, it preserves judicial discretion. That's what the text of the APA says, that's what the structure of the APA confirms, That's what long-standing background principles of equity demonstrate, and that's what every circuit in the country, except the Ames Circuit, has agreed.
Now, counsel, why are we here at all? Why did you wait till the cert petition to raise your Section 655F's argument?
Well, Your Honor, there was a different team of lawyers below. We're not quite sure why they didn't raise this issue earlier, especially given that this is a glaring jurisdictional defect that is an independent bar to this case. And it's worth discussing why. The district court lacked subject matter jurisdiction, and that's something that Respondent has actually conceded on page 6 of their brief. Because the district court lacked subject matter jurisdiction, the Ames Circuit could not hear the appeal.
Well, but we don't lack jurisdiction, so we can hear this appeal, correct? But you're asking us to remand this so the district court can dismiss the case, or, which you don't mention in your brief, transfer it to the circuit court in the interest of justice. Why do we go through that pointless exercise?
A few responses to that, Your Honor. First, it's perfectly right that as a practical matter, this might not make much difference below. But as a matter of law and of policy, when the lower courts lacked, a principle, when the lower courts lacked subject matter jurisdiction, this court's role is very limited. And that's because Congress defines the jurisdiction of courts. When the lower courts don't have jurisdiction, there's no reading the tea leaves to see what will happen on remand, and there's a bright line rule against exercising the judicial
Why isn't
power.
the best reading of our Grubbs case that if it's filed in the wrong court but then it gets to the right court, it's okay for the right court to go ahead and decide the case?
Well, Justice Kovner, we actually think the Grubbs case is a great example of this principle. In Grubbs, this court found that the district court actually substantively did have subject matter jurisdiction. So in other words, the case was initially removed from state court to federal court on the basis of the interpleader of the U.S. As a party, but it was later determined that that interpleader was defective. However, the court still found that substantively there was subject matter jurisdiction because the requirements for diversity jurisdiction were met. Here, no one contests that the district court simply lacked subject matter jurisdiction, not that it was phrased in the wrong way. It was simply non-existent. And that means that the aim...
But it got to the circuit court, and the circuit court could have been a place where the case was filed initially, right? So it feels like it wound up in the right form for the wrong reasons, like in the Grubbs case.
Well, Justice Kovner, that's true. And if they had initially filed in the circuit court, that would have mattered. But the distinction between original jurisdiction and appellate jurisdiction is key here. The circuit court has original jurisdiction, and it could have exercised that original jurisdiction. But here, it would be exercising appellate jurisdiction, which it simply does.
But their review is de novo.
Their review is de novo.
So what difference does it make?
It's true. It might not make a practical difference, but it is a central principle that when a court...
I guess isn't there just a difference between subject matter jurisdiction, which is the authority to pronounce on the dispute, which you don't deny that the Court of Appeals here does have that power. Procedurally, there seems to be a wrinkle below, but that's almost in the nature of, if I might analogize, it's like a venue problem, which typically is not a subject matter jurisdiction problem if it ends up in the right place. Right? It doesn't annul the suit just because you start you started in the wrong place, but you end up in the right place where there is a court with authority, and there's no claim here that the court has somehow warped that authority by deferring or applying some sort of abuse of discretion standard or anything like that. So what's wrong with what happened here?
Well, Justice Liu, I think we'd contest the idea that this is a mere procedural defect. The Ames Circuit has specific kinds of subject matter jurisdiction. It could have heard the case exercising its original jurisdiction if the case were immediately filed there, or it could have heard the case exercising appellate jurisdiction if the district court had subject matter jurisdiction. But neither of those things is the case, and the court lacked subject matter jurisdiction.
Could I tie this issue to what I think is the principal issue on the merits, the question of the remedial authority of the court? So, is there anything special about the idea that this goes to an appellate court with regard to the remedial authority that's available?
Justice Liu, we don't think it affects the remedial authority necessarily, and it's worth discussing that remedial question. We think that Congress established this system where the district courts do not have subject matter jurisdiction in order to make petitions of agency or challenging agency actions more efficient and more direct and eliminate a layer review. But it is worth talking about the merits issue because we think we went on that too. And that's because the text, structure, and history of Section 706(2) all show that vacatur is not the exclusive or only remedy mandated in each and every case. You can see that first with the text of Section 706(2). APA-era sources show that the words set aside, which are the operative words in Section 706(2), were used flexibly at the time of the enactment of the APA. So in a trio of pre-APA cases, this court used the word set aside to describe injunctive relief.
I guess the most telling source for me is the Emergency Price Control Act, right? Because that's where it's used in a statute. It's a big, important statute that the APA's drafters would have been aware of. And tell me if I'm wrong, it seems like courts understood that language to mean set aside as vacatur. So do you think I'm wrong about how courts were understanding that? And if I'm not wrong about that, why isn't that the relevant source Congress would have had in mind?
No, Justice Kovner, I don't think you're wrong. I think the word set aside certainly can mean vacatur, and that's something we'd like to be clear about. We believe that the sources from the APA era show that the word set aside can refer to vacatur, but also to other equitable remedies. And it's worth noting that there are other statutes from that era that use the word set aside to describe not vacatur.
So just in the Price Control Act, do you think their set aside meant vacatur, or it meant vacatur and also potentially the whole universe of equitable remedies?
We thought the latter, Justice Kovner. And it's true that the word was used in the set aside phrase was used in a list that the statute said vacate or set aside. But that's true, enjoin or set aside. But that's also true of the word vacate. For instance, in the Act of June 25th, 1948, another APA-era statute, Congress referred to remedies including vacatur, setting aside, or modifying. So we think that's strong evidence.
Can I stop you and make sure I understand your argument? In U.S. v. Texas, the Solicitor General took the position that under the APA, 706 and 703 interacted, and that a universal injunction was not permitted by the Act at all. That basically you could only decide the case on the basis of an order to the parties. Vacated, it's the parties, set aside, disregard. It's the position my colleague took in his concurrence in that case. And the other side cited it with some approval, so I know you've read it. My question remains, you don't seem to be taking the same position. Am I correct? You've changed your position now, and am I understanding correct that you are only arguing that judges retain all equitable remedies, including a universal injunction if they find that it's appropriate, correct?
That's correct, Justice Sotomayor.
Why has the U.S. changed its position?
We have narrowed our position. That's partly because of the question presented here that this court wanted to consider on cert. We think that there is compelling evidence that the word set aside could mean vacatur, and so we take a narrower view than Justice Gorsuch in the Texas case. We think that if you look at this court's precedents, recent precedents, and the history of the word set aside, or of the APA, it becomes very clear that Section 706(2) is not a draconian, rigid mandate of universal relief in every case. So first, in three recent cases, this court seemed to assume that the word set aside allowed non-vacatur relief. First, in CIC services, this court said that a request for an injunction was, quote, most naturally understood as being part of Section 706(2). Then, in Ling v. Payne, this court said that the APA...
Well, that's, in all of those citations, it's basically dicta, and that issue wasn't joined before us, so it's not compelling in any way. I agree with you that we've said that, but we've never really looked at that issue directly. So it doesn't prove your point.
That's partially true, Your Honor. We think that there is some persuasive weight because in cases like CIC and Bowen, the fact that Section 706(2) could encode relief other than vacatur was actually important to the outcome of the case. So if you look at CIC services, for instance, in that case, the question was whether the request for an injunction was under Section 706(2) or was a general request to deny an IRS action. And if it had been a direct challenge to the IRS action, the Anti-Injunction Act would have applied. But there, this court said, actually, the request is under Section 706(2). I think the history is maybe helpful in understanding exactly how this works. This court has made clear that Section 706(2), quote, did not change the existing law of judicial review. That's what this court said in Kaiser v. Wilkie, citing the Attorney General's manual, the Senate report, and the House report. So that makes the question for this court relatively simple.
Could I take a step back from these kind of doctrinal specifics and ask about this case? So here, right, not before us, is the district court and then the Court of Appeals rulings that OSHA exceeded its lawful authority in promulgating the PPE rule, right? So that being the case, what's at stake in the question presented? Meaning, what course of action is available to a court in the face of this particular version of finding an agency action unlawful? Isn't it, if it's unlawful for this case, isn't it unlawful for every case?
Your Honor, we think there are two potential courses of action that would have resulted in a more equitable remedy. The first would be the remedy of partial vacatur. Here, the court vacated not just the substantive rule, but also the agency's regulatory findings. Those findings took 16 months and 39 statutorily mandated steps. But the court felt, as you can see from the question presented on page 2 of the Joint Appendix, what the court said on page 8 of the Joint Appendix, and what it actually did on page 12, that had no choice but to vacate the findings as well. Second, we think there would have been a balanced decree that would have accorded with the remand without vacatur precedents that we have. So that decree could have looked something like this. The court could have remanded without vacating the agency rulemaking and said, your rule is ultra vires, you need to promulgate a new rule, but because this is an important safety regulation and people might be seriously hurt if it's a
Why isn't that, how is that any different from vacatur plus a stay?
It's very similar to vacatur plus a stay, Your Honor, and we think that both remedies are available. Actually, one of the slight inconsistencies—
But they were, and the other side is saying that you could have asked for either. You didn't.
I think, Chief Justice Sonia Sotomayor, that the other side has denied the availability of stays, of remand without vacatur, but has agreed that stays are available.
Exactly.
And
so why didn't you ask for it?
I'm not sure what the team of lawyers below was thinking. It's possible, we did request more targeted injunctions.
Well, I think the point is that even a rule of mandatory vacatur isn't as inflexible as you're suggesting, which is to say there are ways of managing the process to achieve the basic ends of flexibility, namely giving the agency another chance to think about whatever defects. Stays, according to the cases that have been cited, have been anywhere from weeks to even years. And that would seem like a pretty flexible approach.
That's true, Your Honor, but we think this is maybe one of the inconsistencies in Respondent's argument. The cases that they cite for the proposition that stays are available explicitly weighed those against remand without vacatur, which they also thought were available. And the reason is that all of those remedies are coming from Section 702, not Section 7062. What Section 702 does is it says that courts may withhold relief on any appropriate equitable ground. So there's a bit of an inconsistency here to say that the remedies that Respondent favors are all encoded in the APA, and the remedies that they disfavored aren't. In a way, it's gerrymandering a rule that includes the remedies they like and excludes the remedies they dislike.
Can I ask why it's inappropriate, your position is, that the judge should tailor a remedy? I understand your position, but why? Meaning, the finding here was that the agency lacked authority to pass this rule. The rule requires every employer with more than 100 employees to hire a person. It's not a person they've chosen to hire, it's a person they're required to hire. That's injury to the world. That fits the category of covered individuals. I'm not sure why a universal injunction is, or vacatur is inappropriate in a situation like that. Everyone is equally harmed. Everyone has to pay for a person because the law requires it, not because they choose it.
I see that I'm at time, Your Honor, and so
You can answer the
I'll try to do it as fast as I can. We agree that vacatur often is the appropriate remedy for ultra vires rule.
No, I want to know why it isn't here.
Here, Your Honor, this is a safety regulation. There could be drastic and inequitable consequences from immediate vacatur. No other court has weighed in. There hasn't been any percolation of any kind. And the Ames Circuit itself actually suggested potential intra-vires alternatives that the agency could have adopted on remand. For all these reasons, we urge this court to reverse and remand, and we thank this court for its time.
Madam Chief Justice, and may it please the court, my name is Monica Wang, and I also represent the petitioners. Mandatory vacatur is not only atextual and ahistorical, it is also unconstitutional. Article 3 requires federal courts to tailor the remedy to the nature and extent of the injury.
Aren't there countless examples contrary to that very, very broad proposition, which is to say Congress can specify in all kinds of ways what the metes and bounds of a court's remedial authority is in any particular kind of case?
Justice Liu, we don't disagree that Congress has broad authority to create new permissive relief or to set up elaborate remedial schemes that lead to certain kinds of relief. That's what this court described in Grupo Mexicano. But this court and other courts still undertake an independent constitutional evaluation of whether that remedy is appropriate for the case or controversy at hand. And we think that's because Article 3's case or controversy requirement is very important.
By what standard would that be judged? I mean, what's the rule you're suggesting here as a kind of outer limit?
Well, we think that the remedy should afford complete relief to the injury, but it shouldn't go beyond that because ultimately the injury makes the case.
The other side says that it's not just about injury, that remedies are about punishing, basically, the violation. The idea is that Congress has the right to define what it wants to do with a violation of law. Your point doesn't take that into account.
No, Chief Justice Sotomayor, we believe that it is the injury that makes the case. And that's because this court said most recently in Gill versus Whitford that plaintiff's remedy turns on plaintiff's injury. And we think the way to understand—
But injury is only caused by a violation. And if you're saying that Congress can't judge the importance of that violation and say once you've proven injury of any amount, you're entitled to attorney's fees in a 1983 action. You're entitled, even if you have only $1 of injury, you're still entitled to attorney's fees. I don't know why Congress should be precluded from saying the result of violating the law where you injure anyone, even if it's a de minimis amount, but you still injure them, is the rule is vacated. I don't understand why the Constitution would not permit Congress to do that.
Well, Chief Justice Sotomayor, we think that the injury is connected to the legal violation. After all, the injury has to be caused by the legal violation. And the way to understand the extent of the constitutional violation is to understand the injury that it's produced. I think an example would be helpful. In the Ninth Circuit case of East Bay Sanctuary Covenant versus Garland, in which the Ninth Circuit dealt with an ultra-virus asylum eligibility rule, it didn't look to the legal violation there. It looked at the injury that the rule inflicted on the plaintiff organizations.
Does it matter at all that Congress created these agency powers to begin with? And I guess it would be one thing if we were talking about striking down a statute or invalidating a statute, but I guess just following up on the Chief Justice's question, it seems like if you create the agency, I don't see why you can't prescribe the violation for the agency's abuse of its powers.
Well, Your Honor, we think that the agency still has to, in Congress's authority over the agencies, everything is still subject to Article 3's limitation. We think it is a broad limit, but at the end of the day, Article 3's case or controversy requirement kicks in extraordinary cases.
I guess one thing that surprised me about, I sort of get the argument that a case or controversy is a dispute between a plaintiff and a defendant, and you can't go beyond that. But then I get confused by the rule that you're articulating at the end, which I think is actually often the court can go beyond the parties, and your colleague suggested can often vacate the entire rule. So if the theory is you're limited to plaintiff's injury, why are you saying at the end of the day vacatur is fine?
Yes, Chief Justice Kovner, we think there's two circumstances in which a tailoring principle allows for a relief that reaches beyond the parties. So we don't dispute that non-party relief is available. Those two situations are, first, when it's necessary to afford complete relief to the plaintiff's injury. This court has said in Worth versus Selden that incidental benefits to non-parties are acceptable. And second, the injury may be experienced by plaintiffs as well as other affected parties. And in that situation, the court has also allowed for remedies that also reach to the injuries suffered by similarly situated parties.
Is that how you rationalize class actions?
Yes, Your Honor. We believe that.
So why is this any different here? I mean, the nature of the violation is that the agency exceeded its authority. And what use could there possibly be to having individual litigants like Federico litigate this one by one, plaintiff by plaintiff? If the rule is invalid, it's invalid for all.
Two responses to that, Justice Liu. First, again, in East Bay Sanctuary Covenant versus Garland, the Ninth Circuit, in dealing with an ultra-virus rule, looked at the injury. And we think the injury does matter here. We're dealing with a case here in which Federici has said on page 35 and 44 of its response brief that the injury is a financial one to itself. So financial harm, which got Federici into court, which afforded it standing today, is different from the legal violation that we're addressing.
The injury is they have to hire a person. Every plaintiff has to hire a person. The injury is identical. I know you argue some people might welcome it, but if they do, they can hire the person without the legal compulsion. So no one's stopping them from doing something they want to do. But once we vacate the rule, it's voluntary and not mandatory.
Well, Your Honor, again, it turns on the injury. So the financial harm that Federici has experienced here may not be shared by all regulated construction companies under this rule. There are some that may have had, because we understand the construction industry has many safety and health concerns, there may be companies that have already hired a PPE coordinator, in which case they would not be suffering the same financial harm as a result of the same legal violation. And because the record here is sparse, we agree that in most ultra-virus contexts, the agency record is robust, and plaintiffs in their petitions to the court specify whether there are other regulated parties and whether they've experienced the same kind of harm. But without that knowledge, this court cannot draw logical inferences based on the financial harm that Federici has experienced itself.
Could I ask you one last question? Where in Article 3 are you placing this constitutional limitation?
Yes, Chief Justice Sotomayor.
Standing, which has to do with you have to be harmed to come to court, we house it in the cases in controversy phrase of Article 3. I don't see it anywhere in Article 3 otherwise.
Yes, Your Honor, we believe that remedial tailoring lives in the case or controversy requirement of Article 3. Well, we think that it works hand in hand with standing to ensure that federal courts stay within the limits of a case or controversy when they're resolving the case. As Justice Gorsuch described in his concurrence in United States versus Texas, standing applies at the front end to ensure that when plaintiffs come into court, they have an injury, they can establish an injury in fact that's traceable to defendant's conduct and capable of judicial resolution. And we think after the merits determination, remedial tailoring kicks in once the injury has been established to ensure that when courts are giving out remedy, the scope of that relief is tailored to and limited by the injury established in that case.
Why is it that nobody has articulated this limit as part of the case of controversy requirement before? I mean, it seems like if it's in Article 3, a court would have said it's in Article 3 instead of just it's part of the nature of equity before today. So I'm wondering how you deal with the lack of precedent for you.
Yes, Justice Kovner, we believe that remedial tailoring is an Article 3 requirement, and it goes back to a lot of seminal tailoring cases such as Missouri versus Jenkins 3, where this court evaluated the scope of federal remedial authority as a constitutional question. In fact, just a couple of weeks ago after we turned in our brief, the Fifth Circuit in Missouri versus Biden stated that the remedial tailoring requirement is in recognition of a federal court's constitutionally prescribed role to adjudicate the individual case before it and not the generalized partisan
But
preferences.
cases like Missouri versus Jenkins just stand for the proposition that the remedy must be commensurate with the violation, right? And here, in this particular case, but one might even generalize it to other cases, the nature of the violation is that the agency has exceeded its authority. And it'd be hard, I guess I would ask the question this way, is there a scenario in which this form of violation, this form of unlawfulness, would not simply result in a remedy that is commensurate with the violation, namely vacatur? Under what scenario would that occur?
Yes, Justice Liu, we think that mandatory vacatur is overbroad in APA cases where the underlying injury can be remedied in a narrower manner. So an example would be, take a federal agency that has the statutory authority to regulate only federally funded entities, but it goes ahead and promulgates a rule that affects both privately funded and federally funded entities. In that case, we think that the rule would be ultra vires, but the harm would only be experienced by the privately funded entities. And so vacating the entire rule as to both types of parties would be overbroad.
But the statute says you can vacate part of the rule.
Well, Your Honor, that's not what the Ames Circuit thought below. It thought that the only choice it had was wholesale vacatur, as my co-counsel has addressed. And if this court believes that partial vacatur...
That's overreading what the court said and did, because there wasn't a way to break up this statute. In the example you gave, it applies to regulated entities and non-regulated entities. You can excise the non-regulated entities. But how do you do it here?
Well, Your Honor, there could be...
Your only answer is only issue a vacatur of the parties before the court, correct?
No, Chief Justice Sotomayor. We think that there could be a limited injunction as to Federici and similarly situated parties, which could be other construction companies that are smaller in size but above that 100-employee threshold who have suffered a concrete financial harm.
Why are we in a position to make a choice Congress has? Why are we in a court in a better position? Congress has said if you violate the rulemaking laws, you vacate those rules because they've been passed in violation of law. You're now asking us to have courts below determine what a proper remedy is and rewrite the law to suit what our judgment is about what's a proper remedy, correct?
Well, Chief Justice Sotomayor, we wouldn't quite agree with that characterization. We think that this court is constitutionally bound to hear only cases and controversies and to resolve only cases and controversies.
The agency did something wrong.
That's correct. If the agency promulgated an unlawful rule but it didn't injure anyone,
then get rid of the rule. That's what Congress has told us to do. That's the argument. That's what the court below said.
Well, Your Honor, we think that it's a constitutional duty for this court to clarify for lower courts that there is a remedial tailoring requirement that looks to the injury. And just as standing isn't mentioned explicitly in the text of Article 3, we think that remedial tailoring is implicit in the case or controversy language, and this court should clarify not only its constitutional requirement, but the parameters of the tailoring principle.
Would your theory call into question facial challenges to statutes or regulations?
Your Honor, we think that examples of overbreadth in the First Amendment setting would still be permissible and pass constitutional muster if
How's that
plaintiffs
possible,
can
though?
show...
How's that possible, though? I mean, any facial challenge is a claim that the law, cannot be applied constitutionally in any application. But I mean, the only application relevant is the plaintiff standing before the court on your theory, right? So how could there be such a claim entertained by a federal court constitutionally under your theory?
Well, if the injury is broad and universal enough to sustain broad and universal relief, then we think the tailoring principle is a flexible...
Isn't that exactly what the litigant has brought here?
Well, no, Your Honor, not based on the record. The record is sparse. We think it's different from most APA cases because we don't know how many construction companies are regulated by this rule. We don't know whether they've suffered financial harm. That's the same as what Federici is pleading here. And we think that it would be unconstitutional for this court to vacate in that situation without the factual understanding.
So
I think
you alluded to the utility of our clarifying that this tailoring requirement exists and saying what it is. Can you just tell us what you would have us say that it is? So Article 3 requires that courts tailor their remedy, meaning what?
Well, this court said in Gill versus Whitford that the remedy must be tailored to the injury, and we think that this court can clarify that courts should look to the injury, determine the nature and extent of the injury, how widespread it is, and determine the remedy as such. We think it's a flexible requirement, though. It sets up zones of permissibility.
Do you agree you can look to the nature of the violation, too, as we seem to have said?
Well, Your Honor, it's the injury caused by the violation. So in all the cases, there is a violation that causes an injury, and to understand the extent of the violation, you look at what injury it has caused and how widespread it is. I think that's palpable in cases that we cite in our brief, for example, in Lewis versus Casey.
I guess the thing that I'm worried about is just this seems like a multi-factor test that I'm not sure is going to be very feasible for lower courts to apply. Right? As we're saying this as a constitutional matter, a court would exceed its authority in certain cases by granting vacatur like this, but in order to determine if there's a constitutional violation, you'd have to weigh all of these factors.
Well, Your Honor, we think that's the bread and butter of judging. We think by setting up a zone of permissibility, the tailoring principle asks that simply that courts weigh the facts and circumstances of each case, look at the injury, and then think about the appropriate relief that would fit that injury. But it's a flexible requirement, Your Honor. It's like choosing pants.
So I guess what I'm wondering is, that was very good. What I really wonder is, when is a universal vacatur appropriate? Give me an example of a situation where you thought it would be appropriate.
Your Honor, I see that I'm at time.
Answer the question.
Well, again, we point to East Bay Sanctuary Covenant. There, the Ninth Circuit, in dealing with an ultra-virus asylum eligibility rule, looked at the plaintiff's injury. The plaintiffs there were asylum assistance organizations, and their funding structure were tied to the number of asylum applicants they were assisting. And those asylum applicants were categorically banned from entering this country across the Mexican border because of that rule. So the only way to completely afford relief to plaintiffs in that case would be a universal injunction against the rules application. And that's an example where vacatur or universal injunctions would be appropriate. So we ask that this court reverse the judgment below and remand for an appropriate determination of the remedy. Thank you for your time.
You may proceed.
Thank you, Your Honor. Madam Chief Justice, and may it please the court, my name is Hayley Isenberg, and I, along with my co-counsel Richard Dunn, represent the respondent, Federici Contracting. Today...
So, counsel, why would Congress have wanted to write the statute this way?
Your Honor, we believe that Congress wanted to write the statute this way because this is the balance that Congress struck when it passed the APA. It recognized that administrative agencies provided a great good for society, and administrative governance had a lot of benefits, but it also recognized that agency actions lack the democratic pedigree of statutes and therefore require robust judicial oversight. And so yeah,
there's robust judicial oversight, but this is like a straitjacket on your view, right? It's sort of a claim that in the Congress did some sort of cosmic balancing of, the kind of, on the one side are possible variation in cases, on the other side are sort of strength of the remedies, and it just decided that, well, one size fits all, unlike the pants, I guess, one size fits all, right? Is that what why would Congress write, that seems kind of unusual to attribute such a robust statement to Congress based on just these spare words.
Your Honor, we think that Congress was intentional in doing this because agency actions do sweep nationwide. So it makes sense that the remedy would then match the harm that's caused by the agency when it passes an unlawful rule or regulation.
The one thing I know is that when Congress is unhappy with what we judges are doing, it often steps in. In the INA, for example, they were unhappy with judicial review of discretionary decisions, and they passed a law that said we can't do it. In the INA, they didn't like universal injunctions, and they barred them. Decades before the APA, courts were granting universal vacatures, but they were also granting injunctions, more limited injunctions. Since the passage of the APA, which is decades long, judges have been routinely doing that. Why shouldn't we read Congress's silence to say that it approves and didn't intend what you claim it intended?
Your Honor, it seems as though, based on the cases that our friends on the other side cite, the cases that we've cited, that courts are typically issuing vacatur when agency action is unlawful, and there are a few exceptions, which are the remand without vacatur cases. And there's a few cases that our friends on the other side have cited where courts have done additional to vacatur an injunction. Our friends say that those cases, for example, Bowen and Mayor of Baltimore, are cases where the courts entered an injunction, but in fact, in Mayor of Baltimore, the district court revised its injunction to a statewide vacatur, and in Bowen, the court actually first vacated the administrator's order and then enjoined it to send reimbursements to the party in that case. So we actually think that these cases where courts are doing something else besides vacatur is actually much rarer than it's just not the usual.
Rare or not, it still occurred. It certainly occurred under the Emergency Price Control Act, which you rely on greatly. It has occurred in other settings. How do we ignore that history?
Your Honor, we believe that Congress spoke clearly when it wrote set aside in the APA. As you mentioned, the Emergency Price Control Act denotes multiple different remedies. It says restrain, suspend, enjoin, or set aside. So at the time that the APA was passed, Congress knew how to specify multiple remedies in Section 706(2).
Can I ask about that time the APA was passed? Because, I mean, there's the Attorney General's manual on the APA or commentary on the APA. There are some other contemporaneous sources cited by your friends on the other side. Do you think the AGA manual got it wrong? Do you think those contemporaneous sources got it wrong? Do you have contemporaneous sources of your own saying set aside means vacatur?
Yes, Your Honor. So the Attorney General report that's referenced by our friends on the other side just simply talks about setting aside in the report. It doesn't actually say anything about whether or not setting aside is vacatur.
Well, but it says that 706 restates the present laws to the scope of judicial review, right? So basically, I think it's saying there's no innovation here. It's traditional. I take that to mean the traditional array of equitable remedies are what's going to be available under the APA.
Yes, Your Honor, but we know that the Emergency Court of Appeals and Article III court created by the Emergency Price Control Act at the time the APA was enacted was in fact doing vacatur, and when it did so, it used the term set aside. So we know in the case Flett v. Bowles, for example, the court said that it was setting aside the administrator's order and waste paper order, and in that case, when they set it aside, they stayed their judgment for a period of days to allow the agency or the administrator to amend, which tells us that in fact they were vacating that order, not enjoining it.
I take the point that the law of judicial review at that point allowed vacatur, but it seemed to also allow a lot of other things, right? So I guess that's the piece that you're not carrying over from traditional judicial review.
Yes, Your Honor, and We think that the shall language in section 706.2 is very clear, and courts have interpreted the shall language to be mandatory in cases before. So for example, this court in a case, Maine Community Health, with Justice Sotomayor writing the opinion for that court, talked about how the language shall in a statute is very clear that it's mandatory, especially when surrounding statutes, in that case, for example, we were looking at section 1342 of the Affordable Care Act, when 1341 and 1343 specified that may, the term may, and then 1342 said shall.
Counsel, the problem is, and I do agree with you, I agree shall means it's mandatory, but that's not the issue here. The issue is who's it mandatory against? Meaning a court sets aside and vacates a rule as it applies to an individual is not the same as saying that they have to vacate and set aside the rule as to all other parties. And nothing in that shall answers that particular question. And I think that's what your other side is arguing, which is, yes, it includes setting aside and disregarding what my colleague Neil Gorsuch called disregarding the rule as it applies to the parties. But I don't know where the command that says you must vacate it on behalf of all parties in all situations comes from. That's further than the face of the rule.
Well, Your Honor, the must language, the shall language, connoting must, is simply saying that the court must vacate the action when two triggers are hit. First, when the court finds that the agency action is unlawful under section 706.2, and when it's a prejudicial agency error. And so that shall language is just simply telling the court that when those two things are hit, then vacatur is required. But inherently in vacatur, it is wiping the rule off the book, so it inherently applies to all parties.
Could I ask you one question under 702? Because this language is, I think, very difficult for your position. It reads, nothing here in the APA statute is cited affects the power or duty of the court to dismiss any action or deny any relief on any other appropriate legal or equitable ground. That's the exact language of 702, and it refers to the power of the court to grant relief according to appropriate legal or equitable grounds. What do you do with that language?
Your Honor, we believe that while section 706.2 set-aside language does require a certain remedy when unlawful agency action occurs, it doesn't divest courts from other background equitable remedies such as an injunction. The case Bowen, for example, or Department of Commerce v. New York.
But it also says deny relief on any other equitable ground.
Well, Your Honor, we think that the prejudicial error language in section 706.2 gives courts that discretion to, when they find an error to be not prejudicial or harmless error, that they don't have to vacate the rule. That's one of our triggers to mandatory vacatur.
I guess, if I may, I guess I'd like to understand better how you deal with cases like Bowen, which are sort of like, the vacatur plus, right? Where does the plus come from?
Your Honor, we believe that the plus comes from section 706.1, which is right above section 706.2 in the APA, which tells courts that when agency actions do not act, so when there's inaction, courts can compel agencies to act. And so we actually think 706.1 and 706.2 work hand in hand, and in the Bowen case is a great example. In that case, the court issued vacatur to make sure that the administrator's decision was wiped off the books, and then 706.1 allowed the court to enjoin the administrator from issuing the reimbursements in that case.
What do you do with the Emergency Price Control Act and Heck versus Bowles? There, the court had language that said, when a violation of the act was found, an injunction shall be granted. Same mandatory language as here. And the court said no, that courts always have discretion to deny or grant an injunction. So if the court could read that mandatory language to always retain the court's discretion, which is the way I read 702, why doesn't that principle apply here?
Your Honor, the reason why the Hecht principle, if there is one, does not apply here is because in that case, the courts were interpreting Section 205 of the Emergency Price Control Act, which talked about the injunctive relief that a court could give the administrator if a plaintiff or a party had violated the order that they had put down. And in that case, it gave courts broad discretion through a term called other or other orders. So that section of the Emergency Price Control Act said, shall grant injunctive relief, but then it said, or other orders. And so the discretion that courts had in interpreting Section 205 of the Emergency Price Control Act came from that or other orders language, not from the shall language, of course.
Can I ask you about one other portion of the APA, or another adjoining section, which is 703? So it seems like you want the remedy that a court should give at the end of the case to come from 706, and I'm wondering why 703 isn't the more relevant place to look, right? It talks about what kind of suits a plaintiff can bring, and there it's things like an action for declaratory judgment, or a writ of prohibitory or mandatory injunction, or habeas corpus. It just seems natural to think if that's the suit that the plaintiff's bringing, at the end of the case, what a court is going to issue is one of those things. And then I think the section we're talking about is more doing what the Chief Justice said, which is saying when you're doing that, when you're deciding whether to grant any of those things, set aside something that's unlawful. But tell me why I'm wrong about that.
Well, Your Honor, first I would say that is not what our friends on the other side have argued for here today. They have not argued that set aside should just be interpreted as disregard. They have argued that it should be interpreted as vacatur. Actually, in their reply brief on page 1, they've argued that it should be the ordinary remedy for APA violations. However, in the alternative, assuming this disregard language, we believe that Section 703 does specify these other remedies, but it works in the same way that the injunction in Bowen or the injunction in Department of Commerce works, and that after doing the mandated vacatur required in Section 706, the court does have discretion to, if the party has asked for another form of relief, which it's authorized to do under Section 703, could then issue that relief. And I would also support that point with the fact that 706 is the clear remedy section of the APA, and that makes sense based on the structure of Chapter 7 of the APA. We see that 702 first waives the United States sovereign immunity and says that that the United States can't be sued for money damages, although I would note that is a remedy that our friends on the other side have suggested that set aside could mean on page 5 of their reply brief. In 703, it then lays out additional remedies that a party could ask for. In 704, in 705, it then says that a court could issue preliminary relief. So again, right before reaching the merits of the case. And then 706, at the end, once a court has reached the merits of the case and determined that an agency action is unlawful.
I mean, normally what the party asks for sort of limits what is going to be at issue in the suit. So if I bring a suit for damages for something bad that happened, the court is not going to award an injunction as the remedy at the end of the day. And here that seems to be what you're suggesting, right? That a plaintiff can bring a suit and say, what we want is a declaratory judgment, and the court has to then vacate the rule in that action?
Your Honor, we believe that the APA is just different than other statutes because the APA set out to create this balance for large administrative actions, and then to counter those large administrative actions, it created a large remedy that courts do have to issue when an agency violates the APA, because when the agency violates the APA, it impacts the entire nation or all regulated entities that sweep across the nation. So we think it makes perfect sense that even if a party were to describe one type of relief that it would want, that it would make sense also to keep the agency from continuing to enforce an unlawful regulation against other parties.
I guess I'm going back to my colleague's question. What you're suggesting is if a plaintiff just wants a declaratory judgment action and it walks into court and says, 703 permits me to do this, and all I want is a declaratory judgment, you are suggesting that 706 compels vacatur even if it's not asked for? That is more, to me, an unusual way to hamstring a judge. because you're really saying Congress decided to hamstring plaintiffs or petitioners in the relief they could seek in a provision that says they can seek all sorts of relief in addition to a 706 action.
Well, Your Honor, we do believe that that is what the APA calls for. However, it's notable that the APA, although it does require vacatur, again, it does have to find the agency action both unlawful, and it has to reach that on the merits in a judgment, and then it also has to find that the agency action is prejudicial. So it's very possible in those cases that maybe that the agency action is not prejudicial. And of course, the court can always issue a post-judgment stay, or they could voluntarily remand in the cases where maybe a plaintiff has asked for some other form of relief.
What does vacatur mean in the context of a case where a litigant is essentially saying, as applied to me, right, this rule is unlawful? Meaning on the basis of certain facts or, basically cabining the claim to the way this rule applies to me. What does vacatur mean in that context?
Your Honor, I believe that vacatur would still mean wiping the statute, or the regulation, off the books. But in that context, what you're talking about, a certain factual scenario, the agency action either violates procedures prescribed in the APA, or it's unlawful due to a violation in section 706 2A through F, or it's not. The specific facts of a certain person aren't necessarily going to change.
Suppose the rule in this case had simply said, you shall hire one PPA coordinator if you have more than 100 employees, to the extent it is not overly burdensome to the company, right? And same case, litigant comes in and says, well, as applied to me, this is going to be overly burdensome.
Your Honor, again, I would say that vacatur is the correct remedy in that case, because in this case...
Of the entire rule?
Your Honor, I see that I'm at time. May I answer your question? Yes, Your Honor, of the entire rule, because in this case, the problem is not only that it's harming Federici in terms of the financial injury, but the problem is that the OSHA PPE rule has violated the delegated authority that Congress gave OSHA in the OSHA Act. So regardless of the facts of the case, the PPE rule is unlawful and has to be vacated and can't be applied to anyone. And for the foregoing reasons, we ask this court to affirm the judgment of the Ames Circuit. Thank you.
You may proceed.
Madam Chief Justice, and may it please the court. My name is Richard Dunn, and I represent Federici Contracting. I will argue that by mandating vacatur, section 706(2) of the APA does not violate the Constitution. Article 3 leaves it to Congress to determine what remedies are available in federal court. And when a plaintiff with standing can establish that a defendant has committed a legal violation, nothing stands in the way of the court taking the further step of wiping that illegal action off the books at the insistence of Congress.
Are there any Article 3 limits on the remedies a court can order when a legal violation is established in a lawsuit?
Well, we absolutely believe that you can't require courts to issue advisory opinions, for example. So if Congress tried to set up a scheme where a court would issue an advisory opinion or something of that nature, but we don't...
But there's no case or contract, there's no live dispute, right? So let's say there's a live dispute. Congress can mandate any kind of relief it wants in response to that suit.
Well, Congress cannot say something like, we're going to start ordering other rules that OSHA has promulgated off the books. If those rules...
I guess I just don't see, so what's the principle? What's the, it seems like you are saying then there's some kind of remedial limit in Article 3, and what is it?
So it's the scope of the defendant's legal violation. So here it was the unlawful rule that caused the injury. Once that violation is established, that rule can go off the books. We could imagine Congress maybe saying, well, start then scrutinizing other OSHA rules to see whether those are also unlawful, if this one is, and that's a limit.
Can I give you a hypothetical?
Yes.
This is a gender discrimination case, and Congress is concerned about gender discrimination. Can Congress say, in any gender discrimination suit, the court can award damages not only to the plaintiff, but to anybody else who it decides, based on the evidence that it hears in the case, was injured by the defendant's wrongful conduct?
You could do that if a plaintiff with standing is able to come in and then say, this defendant violated the law, discriminated. That I don't see any problem with that. We cite this case EEOC versus Wilson from the Sixth Circuit, where you had a sexual harasser, and the court said, we're going to enjoin you from actually accompanying any of your employees off the premises. That's lawful conduct. Any other employees as well, because of your track record. And this is important for civil rights litigation and other things like that.
You're fighting the hypothetical, all right? Because there has to be some limit. You can create your own hypotheticals if you want, but let's assume that Congress came in and said, plaintiff comes in, they prove they've been injured by a particular violation. Now every plaintiff is entitled to $1 million. What is that? Is that simply a due process violation? But it's still unconstitutional. And that's basically what the other side's arguing here, which is there's some inherent limiting principle, constitutional principle, against Congress's ability to structure some remedies.
Your hypothetical, Chief Justice Sotomayor, and Justice Kovner's hypothetical sound exactly like a class action, where you have a plaintiff with standing come in and say, I want $1 million, not just for myself, but for all other putative class members who are not going to come before the court. They're not going to establish a case or controversy.
In most class actions, not all, but in most class actions, the amount of the injury is proven and set according to some objective criteria. How much each paid, how much they lost, etc. So it's not just the figure picked out of the hat, it's one in which the amount of the injury is also common to all the parties.
Of course, but you could have a damages...
My example was one that was different. It doesn't matter what the plaintiff's injury is, Congress is saying it's worth $1 million.
Oh, so you're asking about statutory damages in that situation?
Basically.
Well, I think that certainly Congress can prescribe statutory damages, and we think that Congress has done that in many statutes, such as treble damages in the antitrust laws, and we say that is fine. Congress can...
It just seems like the case or controversy limit and the idea that somebody's got to have standing to bring suit carries with it the idea that all the court is supposed to be deciding is the dispute between two particular parties. So it seems strange to say as soon as there's some dispute before the court can order relief that goes way outside of it.
That is exactly what this court did in the iconic school desegregation cases. It did that in the recent case of Brown versus Plata. It is so essential to civil rights litigation to vindicate these rights when you have one plaintiff or one group of plaintiffs come in and say, our school is segregated in this school district, and the court in cases like Swan versus Charlotte Mecklenburg, Milligan 2, says, we are going to order this district to desegregate its schools. Those were some of the most shining examples of this court vindicating the law, not just for the named plaintiffs before the court, but for other future hypothetical victims.
Well, you omitted the first Milligan case, which went the other way, which is to say the court there drew a line in terms of the remedial authority of the court because it said it wasn't commensurate with the violation.
But in Hills versus Gautreaux, Mr. Justice Stewart distinguishes the first Milligan case and says the problem with Milligan 1 was that the court started trying to enjoin school districts outside of the Detroit metropolitan area.
But the claim was that that was necessary to the remedy, but the court simply disagreed. What is that? Is that an equal protection holding? Is it an Article 3 holding? What is that?
The way that Hills describes what happened in Milligan 1, and I think this is very instructive, is that the court was trying to enjoin defendants who had not violated the law. You had these other school districts that were not shown to be discriminators. They were not shown to be violators, and the court said, we need to make sure that we're only enjoining the discriminators. And in Hills, this court reaffirms a very broad conception of equity. You have even Justice Marshall, Justice Brennan concurring in Hills, which says we're not limited to enjoining the Department of Housing and Urban Development in only the area of Chicago. We can go broader than that. So this court, time and again, has exceeded OSHA's supposed tailoring principle in some of the most iconic civil rights cases, and those were not unconstitutional.
Can I ask about sort of a constitutional avoidance kind of principle? So if I have a case or controversy concern here, is there a constitutional avoidance principle that applies and would say just interpret the statute narrowly to allow a variety of remedies to avoid that problem?
Well, I do want to assuage your concerns about case or controversy before we're done today, but if you did have that concern, I don't think that constitutional avoidance would step in here. We think that 7062 is very clear in the way that it requires vacatur with the mandatory language of shall and the compelling evidence that set aside means to vacate, as my co-counsel put forward. So we don't think that constitutional avoidance has ever been thought
just
to.
because the statute's so clear, so we never get to constitutional avoidance? Is that the theory?
Well, I do want to say that the statute is very clear, and I don't think you would want to get to it, but I really want to assuage your concerns in the first place. I want to fight this hypo a little bit because I do not want you to have concerns about the case or controversy requirement. It would be such a drastic step for this court to, for the first time ever, say that the case or controversy language requires this tailored relief. And it would be disavowing so many important decisions.
Because I think you would have said of all of those civil rights cases that the relief was appropriately tailored to the nature of the violation in those cases. And all your friends on the other side are saying is courts have to engage in that kind of traditional remedial tailoring in order to comply with their Article 3 responsibilities. So is that going to disturb the civil rights cases and other cases that you're relying on?
Not at all, because we agree that it's about the scope of the defendant's violation. Our friends on the other side want this court to start doing what the Brown 2 court never did. The Brown 2 court did not say which actions precisely how we consolidated, which actions, which plaintiffs are before us right now. How can we make sure we're only ordering those schools that are segregated as to these plaintiffs to become desegregated? The court said it's time to desegregate, and we think that is the principle. And if you look at a case like Brown versus Plata in 2011, this court considered, pondered, and then rejected OSHA's tailoring principle in very clear terms. Justice Kennedy there says, we have prisoners with mental and physical disabilities alleging that certain prison conditions are unconstitutional, and he said, we're going to enjoin all the prisons from doing these violations as to everybody, not just the medically disabled plaintiffs, because these are other people, are the system's future hypothetical victims. And when you go that broad, the tailoring principle has been disavowed.
Can I ask you, counsel, so you are aware, I'm sure, of an adjacent debate over nationwide injunctions.
Absolutely.
And members of this court have written about this. Do nationwide injunctions present any constitutional concerns, in your view?
Well, I have a few responses to this, and I'm glad you asked. So nationwide injunctions are a bit different because here Congress has required, or at minimum authorized, vacatur, whereas Congress has not ever authorized nationwide injunctions. So there's the problem of congressional authorization. But if you're referring to Justice Thomas's concurrence in Trump versus Hawaii, where he suggested that nationwide injunctions might be inconsistent with Article 3 due to a tailoring principle, I would make 2 points. The first is that Justice Thomas was making a tentative suggestion in his short concurrence. He said, I'm skeptical. I think Article 3 might require this, but subject to further study. And we are confident that if Justice Thomas were here today with the benefit of Federici's briefing and oral argument, even he would go with us on this point.
Has he changed his mind when he's been skeptical before?
The Baldwin dissental, Your Honor. The Baldwin dissental, he repudiated the Brand X doctrine in no clear terms.
That's
he
true.
said, my Brand X opinion is unconstitutional.
But he wasn't skeptical in the previous case. He just admitted he was wrong later.
He wrote Brand X and he said, this is so necessary. And then in Baldwin, he said, I was totally wrong. He always changes his mind. So we think he would here too.
Wait a minute. Not always, but he has on occasion. Having said that, there is the question that he raises a serious issue. And I see your distinction between a vacatur or an injunction, but the line is very fine. You are right that generally when we speak about vacature, setting aside, we're thinking of vacature. When we're talking about restraining or prohibiting someone, we're talking about an injunction. But they're often flip sides of each other. And so it seems, I'm seeing hard-pressed to think that a Congress who permitted the court to stay its vacatures pending appeal, that directs that a court looks at prejudice in determining the remedy, that same Congress is going to say that courts cannot look at the record as a whole and take due account of whether the remedy is disproportionate to the violation. So in many ways, it's the same question. If I can, and you can see this in your briefs, if I can order someone to, if I can say error is not prejudicial and not order vacature, wouldn't the Constitution say something about hamstringing a judge from being able to say a particular remedy is inappropriate or disproportionate to the harm?
Well, I would remind this court of TVA versus Hill, the famous snail darter case where Congress chose the snail darter over the dam, and there it was held that Congress could restrict the court's powers and equity via a statute requiring an injunction in a certain case under the Endangered Species Act, and Weinberger versus Romero Barcelo affirmed that. As to nationwide injunctions, I want to assuage this.
I do want to say that a snail is a living creature. Money is not living.
That is true, but even Weinberger versus Romero Barcelo affirmed the principle that was articulated in TVA versus Hill. And I want to assuage this court that even if you have concerns about nationwide injunctions in all circumstances, nothing is going to stop this court from encouraging or even requiring lower courts to take into account certain equitable considerations when deciding the scope of remedy.
I accept all that, and I think that's fine. But I guess where I was sort of heading with the nationwide injunction question is, I mean, we focus a little bit on case and controversy, which is familiar because it's in the text. But is there an implicit structural principle somewhere in Article 3? The notion that, first of all, lower courts, no disrespect to any of my lower court colleagues, but lower courts are actually not constitutionally required. And the notion that not all courts in the federal system may be vested with the same degree of remedial authority, maybe that has something to do with the intuitions here, that you have single federal district judges being required, in essence, to make nationwide policy. We don't call it that, but that is, in effect, what happens. That seems a little bit that's a grand proposition against the backdrop of a provision in the Constitution that doesn't even say that such courts are required.
Well, we think that the Madisonian Compromise supports our position here because the courts never had to be required, but once they are required, it's up to Congress to invest them with jurisdiction and to structure them. And even Grupo Mexicano, Justice Scalia's opinion, which had a very restrictive conception of equity, one of the great virtues of that opinion is it says Congress can dramatically expand. Major doctrinal innovations can be authorized by Congress that were unknown to history. And we think that that is what Congress
Without limit?
Subject to the limits that I was discussing with Justice Kovner, for example. I mean, if Congress tried to order punitive damages over roughly 10 times the amount of the violation, we would say that violates the due process clause of the 14th or 5th Amendments in State Farm versus Campbell and BMW versus Gorse. There are some limits on this, but we don't think that Congress is limited from saying when you, court, in an exercise of your jurisdiction, find that a rule is unlawful, you are somehow prevented from giving effect to Congress's command to take care of that unlawful rule for the benefit of future plaintiffs who are going to suffer the injury, as Your Honor was suggesting earlier in the argument.
So I guess I get the argument as to vacator specifically and why Congress could authorize that as the exclusive remedy under the APA. The thing that's giving me pause is the much broader position, which is basically Congress can do anything it wants and doesn't need to, can forbid courts from considering the nature of the injury and the nature of the damages. It can require a court in any kind of case where it finds a violation to impose any kind of remedy Congress wants. I guess why does having some kind of tailoring in Article 3 cause any kind of problem?
I think Congress has broad power over the federal courts, and Congress can require federal courts to do what Congress tells them to do when it comes time to issue a remedy. And I think in the APA context, you had that monumental compromise that Wang, Yang, Sung, and Vermont Yankee, and Perez versus mortgage bankers all affirm that this was a dramatic change in our country, and Congress said, we want to vacate at the first determination of illegality. And for those reasons, we urge you to affirm the judgment below. Thank you.
Madam Chief Justice, and may it please the court, we'd like to make 3 points on rebuttal. First, respondent cannot find a hook for the injunctive relief that it concedes is available under the APA. In its colloquy just a few minutes ago with Justice Liu, respondent suggested that Bowen placed injunctive relief in Section 706(1). But that's simply not what Bowen said. Bowen said, quote, Section 706(2)'s plain text allows courts to provide complete relief, and it then went on to explain that relief included vacatur and injunctions. Second, respondent has insisted, both tonight and in its briefing, that the words set aside have a clear and singular meaning. But it has cited no majority opinion from any court in 7 decades of interpreting the APA that has ever held that. Instead, it relies on 2 concurrences written by the same judge. Third, respondent has attempted to demote the tailoring principle from its constitutional status by listing well-established remedies that permit non-party relief. But the tailoring principle is broad, it is flexible, it permits non-party relief. What it does not allow is a remedy that is universal.
Counsel, can I ask you a simple question? We eschew magic words in almost every context, whether it's in waiver of sovereign immunity, in all contexts we don't ask for magic words. It appears to me that you're arguing that set aside is broad enough to encompass every definition in the dictionary. But what would be clear? Meaning, do we require Congress to use the magic word, vacate?
Your Honor, we think that were it not for the fact that set aside is a singularly flexible term, that this court had used to describe injunctions, that Congress had used to describe injunctions, that a term like that could work. We don't think it's asking for magic words to say that when a court uses a very flexible term, they mean to provide for very flexible relief. And it's worth just talking a minute about the history of the APA. As Justice Kovner mentioned a few minutes ago, the Section 706(2) did not change the existing law of judicial review. And that existing law of judicial review is very clear. It was equity, the discretion to mold each decree. And that makes a lot of sense in the APA context. The APA is not an abstract document. It is practical. It is pragmatic. It regulates all kinds of conduct in all different contexts. As such, it would be wrong for this court to pronounce a sweeping rule that would rigidify the APA and prevent the kind of equity that courts for 7 decades all across the country have done. We urge this court not to go down that route and instead to conform to the precedent of the past. And we thank this court for its time.
Court is recessed. We will reconvene after deliberation.
All rise. You may be seated. Please remain in your seats while judges deliberate. They will return and announce the award shortly. All rise.
Hello, everybody. So what's the protocol? Do we announce the winners? Do you ask us who the winners are?
Yes, Justice Sotomayor, you will announce the winners, please.
Oh. Justice Liu said to me, we can't keep them in suspense. All right. So best brief goes to petitioners. Best team goes to respondents. And best oral advocate goes to Richard Dunn. Now, for all of you in the audience, you should know how hard a decision like this is. And I will explain why. I don't do many moots anymore because it's a lot of work for us too. And I continue to say yes on occasion for one very important reason. Watching the skill of all of you, for me, is inspiring. You keep me doing what I do. You have to understand that my work is not easy. And too often, in recent times, it's difficult. And I need to have my spirits lifted too, and you do that. Watching your devotion to your craft, to learning and mastering it, and doing presentations that rival what I see before me in court, tells me that we have a younger generation of lawyers who will follow the banner of justice. And so I took that inspiration from seeing all four performances. From reading the briefs, our decisions were very difficult. Both sides' briefs had incredible strengths. Both sides had stuff you'll learn about. But the point is that the marginal difference was just that. And the same with your advocacy. Every one of you was further skilled than I was as a lawyer leaving law school. You will reach even greater heights than me in your professional work because of your dedication and willingness to work so hard. and do such a great job. Thank you for the time you spent on this. Thank you for giving me hope. And thank all of the people who supported you. The brief writers, not the case writers, what a great job he did. It's coming to a court soon. Undoubtedly to mine soon. The point is that every part of this has been really impressive, and I know that it's been a huge team effort. Harvard, John, where are you? You should be very proud of your students.
I'll just add my congratulations to all the competitors here today and to all of the students who participated in all the early rounds as well. This is a tremendous activity. I'll just echo what Justice Sotomayor said, which is I would be so delighted to see any of you argue in my court. You would raise the bar, honestly, that's not anything wrong with our advocacy, but this is a very, very high standard. And you may not know that, actually, until you spend some time in the profession as to how excellent you have become in a short period of time. You may be used to seeing each other, do this at this point, but you have really set a very, very high bar. I just want to make one quick comment about the nature of oral argument, which all of you keyed in on in a certain way, which is that you prepare so much, in terms of the materials and the doctrine, the case law, and all your, substantive arguments. But fundamentally, oral argument is a human interaction, right? And so all the other parts of your skill set, your emotional intelligence, your people skills, your ability to sort of sense the room and to sense the bench, all of that is equally important to your success as an advocate because it goes to your ability to be heard. You may have the best arguments in the world, but if you can't be heard, right, then it won't do you any good. And all of you had a very, very nice sort of radar for these kinds of things, and we don't really teach these things, but it turns out that these are some of the most important skills you'll ever have as a lawyer. I just want to make one last remark, not about the competitors, but about all of the rest of you who are here. We had a very nice dinner, ahead of this event. And here and at the dinner, I just want to say how lovely it is that all of you showed up for each other. And that's not something to be taken for granted. It's what it is to be a community. And when I hear you cheering at the end of the event, consider you're not cheering, people's viewpoints, you're not cheering their ideologies, you're cheering their hard work, you're cheering their teamwork, you're cheering their excellence. And that is something that I hope you sort of make a mental mark of in terms of what this event has meant for the community and take that into the other things that you do at this school. Thank you for the privilege of being part of this.
I can't really improve on any of that. I think I can just co-sign it. These competitions are super fun to do, so thank you for having me. I do think the level of briefing and oral advocacy was as strong as any moot court I've seen. You guys are really tremendous and are ready to have careers in this kind of work, all of you, if that's something that you want to pursue, and I hope that it is something that you want to pursue given how strong you are at it already. And I think this is like kind of an incredible moot court. I'm not sure if there's any other moot court that is as intense, that goes these multiple rounds of briefing on these cases that are like totally new to like Ames court only cases. I think it is probably the most intense moot court experience out there, and you guys have all kind of hit it all out of the park in that. So congratulations to all of you.
adjourned for the evening. Thank you all for being here. The families who have come, I hope you know why you should be proud of your children. You've seen it. And believe it or not, all that money you've paid has paid off. Thank you all.
Guys.
Please be seated. Thank you all so much for attending tonight's oral argument. We would like to thank the Dean's Office and the Dean of Students' Office for all their support of the Ames program, and we would once again like to congratulate both teams on an amazing performance. We invite all of you to now join us for a reception at the pub in Wasserstein Hall, and for those of you who are 2Ls, we hope to see you here next year.